filed here.
In the Supreme Court matter is still pending.
Matter is still pending.
Some Roshan or Rohat, no?
The latest status on the Honorable Apex Court. It is tentatively fixed on 15th of this month.
Your Lord's letter. Order passed on 6 November may be extended till July at least.
So this stay application you have solved. This can number 2. 1 week injunction was passed.
Yes, Your Lord.
Have you solved? Hello, have you solved this scan application of all? You have not solved.
I think I have not, sir.
You also have solved. Before taking certain and hardware complex.
Yes, sir. They are resident of Havelock. It is not possible to serve in
The mentioned it was earlier. There was no notice, no application even has not been served. How the injunction was granted to you?
that on that can too it was granted.
The can was without service.
Yes.
Nobody appeared on the other.
Yes, sir. Nobody is appeared. It is recorded here. In spite of service, nobody appeared.
Where do they stay? They are not in the Blair.
They are in the Hudway. Oh, sorry, Havelock Island. Havelock Island. The order passed on 6 June. I have served upon the authorities and the private respondent by send a speed post to them.
But upon the private respondent,
That is the not the but authority and the respondent.
there is no.
No, because authority was informed that yes. Renuka, they were sent by speed post the intimation of that order. But
Yes, sir.
speed post is not with me. Letter is there, Your Lordship, which was served upon the authorities also because they may not registered any document in between. Postal slip is with my client, Your Lordship. I could not collect the same.
You have communicated to the authority.
Authority.
That the private
I
respondent. You are
submit, Your
not
Lordship,
party to this.
I sent them by speed post.
Wait,
Postal receipt is with my client. So I'm unable to.
You have to bring all these things, sir.
Mr.
Yes.
Otherwise, you will sit a. Produce, we are passing it over, if you can bring the document, affirmation, affidavit and come to us.
Let it be fixed tomorrow, Your Lordship. I will affirm the
Yes,
affidavit and that.
because there has to be some record, no?
Yes.
And in the meantime, if you know if anybody has been engaged.
Yes,
You give a notice to
Yes.
you and tell us tomorrow. Tomorrow to be mentioned.
Your Lordship, may I take back that letter?
This thing. The post. Yes. That Supreme Court ordered 6 weeks, you said now.
Yes,
When was that order passed?
7th of March. May I just check and
7th March 2025.
five this year? Yes,
Yes. Yes, Gautam.
Item two, WPCT 11 of 2025.
My lord, I am for the petitioner appellant, but my lord, we have just now received the brief, my lord. It can go to the next circuit.
Your lordship, there is a defect in the application.
My lord.
There's a defect in the application. They have not made Union of India as a party to the case.
We'll do that, we'll rectify.
Party in the tribunal,
We will rectify the defect, my lord.
because the entire case is relying upon the decision of the Union of India. It should be, your lordship, they should have.
We will add
What is procedure here?
main,
Must have been placed before this time, the second.
must have been. Actually, my lord.
WPCT,
I
your
don't
lordship,
know.
I don't know.
But we'll do the correction, my lord. We'll add the Union of India and let it come in the next circuit.
But not as a petitioner.
No, we don't have authority. That is why we will make them as pro forma respondent.
They are relying upon the decision of the Union of India to.
What is the matter?
I just now received the brief, my lord. Miss Nag argued it in the cat. I think she may be able to.
It's relating to promotion, your lordship. What they have done, there was only single post. 50% by promotion, 50% by direct recruitment. They filled it by direct recruitment initially. Now, when that particular person retired, it ought to have been by promotion next. Because only one post is there. They are saying because it was filled up initially by direct recruitment. So second time also we'll be filling up by direct recruitment.
Actually,
This is the case.
my lord, it turns on the word or and, because my lord, what has happened is the cat has proceeded on the basis that it is or 50% by direct, 50% by promotion. But according to the administration, my lord, the recruitment rule, there is a semicolon. So it has to be read that at all times it has to be 50% by direct and 50% by.
In any circumstance, if one
So if
post
it
is
is-
there, if one post is there, one time it is to be filled by direct recruitment, another time by promotion. That is the
Take necessary steps, it will appear before me.
My lord, we'll do that.
Next circuit.
My
Lordship, may I submit one thing, let it be recorded, your lordship.
Yes, ma'am.
About the defect, so that.
My lord may say that.
Same thing should.
No, my lord may say that we have sought permission from your lordship to add the Union of India as pro forma respondent.
It has to be, otherwise your lordship, next circuit, same thing will happen, it will be delayed.
Show us the original application, first title.
Page number 40.
Page 40.
Yes, ma'am. Respondent number 1 is Union of India. Ah.
So we are granting you leave. You make the necessary
Yes, ma'am.
correction here and now. Mr. Chakraborty, learned advocate appearing for Yes, sir. Next matter.
Item three, affirmative to of 2024.
I received paper book. It will take time for hearing. So it is two appeals were there, FMAT two and FMAT.
Yes, you were not there. Mr. Jaipal was yesterday here.
I received paper book.
All right, sir, we keep it in the next circuit. It won't be possible this time. Next circuit.
Yes, sir. This will appear along with the FAT three, Your Lordship.
Why?
Because they, from same judgment, two appeals was filed. One is appearing. They filed the combined paper book in respect of it. Suit and counterclaim was there. So two appeals. was-
Alok, do we have to pass any formal order? Do we have to pass a formal order? Now, how do we, what is that FM, what is the number of that appeal?
3 of 2023.
This FMAT has been filed by Mr. Khan. No, by Mr. Jaipal.
Both appeal filed.
Oh, acha, acha, acha. The present appeal
Item 4, affirmative arbitration award 1 of 2025.
My lord, I am appealing for the appellant. This is an arbitration appeal. My lord, these are arbitration matters.
Yes, Mr. Sipa.
Lord, this is arbitration matter. It comes under Old Arbitration Act 1996.
Setting aside award.
My lord,
Setting aside of
setting
award.
aside award. I have filed 34 application before district judge. It has been rejected. Then I have come before the under 37. My lord, in this case, already in the trial court, this honorable court granted stay since the old act applicable. Old act is applicable because under old act, once appeal is filed, the stay is there. I have enclosed the order of the Honorable High Court, page number 59.
Have you served?
Yes, my lord, online, through online is appearing. This.
Lordship, may I submit a lordship? I am in an online note.
Yes.
Lordship, we have not received the copy. To the junior of the council told that that the matter is listed before your lordship today. We have not received the copy. Neither the respondent have received any copy. The notice is unserved.
You are for the respondent.
Yes, sole respondent.
Yes, I was the arguing counsel in the additional district judge, but here the respondent has not received any notice. They have just intimated the respondent to appear before your lordship via WhatsApp only. That today the matter is listed. We have not received the brief.
Are you appealing for that respondent? Do you have instruction to appear in the appeal?
Yes, your lordship. Only today I am the counsel for the respondent, but officially no notice has been served.
How? Complete service?
I shall give, my lord.
Our I shall give on the last day you have come.
My lord, only one request, my lord. At least I pray that limited stay may be granted because
No.
this honorable court already granted, my lord. Kindly see, my lord, page number
Let them
59.
come with that. What is the problem? You will get
My lord,
this.
the execution is pending fixed on 28th April.
Mr. Shivbalan, without service, we cannot take it up.
My lord, he appeared limited is a. I shall serve, my lord. I shall come back. Limited stay may be granted, my lord. Kindly
No,
see
your lordship.
and
Mr. Shiv, had Mr. Shivbalan learned advocate appearing for the appellant. It appears that service of
service of this copy.
he has not got it.
Well, I shall send the copy. I shall send the copy. But
But
his appearance is there.
his appearance is not there. He has not yet got Vokalatnama. He said that I appeared before the trial court.
Arguing
I will mail him. I have sent him through WhatsApp, my lord. I have sent
If he is not what he is saying, you have to send it to the respondent concerned.
my lord. Award was passed on 19th March.
Lordship, this award is dated of 31st May 2007, and the Honorable Additional District Court set us restored the award on 19th March. It was the order of this Honorable Court that the execution will be stayed until the dispose of the 34 application. Now 34th application is dismissed, so we are proceeding with the execution.
My lord,
That is the matter, I know, your lordship, but till now we have not served any copy of this 37 application.
But-
Lordship, kindly may post it to the next circuit.
No, we cannot record your appearance because you are saying.
Yes, your lordship. Yes, your lordship. Let them send it to the respondent address. With the next circuit, we'll file the Vakalatnama and reply to it.
no, I want the interim some protection may be given.
You say that in the execution you say.
But that
You will not insist for that.
that may be recorded, my lord, because the London district was-
How can I record a person who is not even engaged? We will say that you will serve when the matter is returnable. You say, tell it to the court below. Third, Mr. Shivwal.
council may be directed not to proceed with the execution matter. At least some order may be given, my lord, till the limited.
We cannot, Mr. Shivwal, understand on what basis you are praying for stay.
My lord, kindly see my page number 59.
59.
Earlier also this honorable court, I approached this honorable court.
This is against which order?
against the interim order of proceeding with the execution case. During the pendency of the 34 petition, the district judge has proceeded or directed the executing engineer to file asset and thereafter have challenged that order of interim order of execution, and this honorable court has granted stay till the disposal of the 34 petition. Now the 34 petition has been disposed of and I have come before the appeal within time before this honorable court. So, my lord, I am entitled to stay, my lord, and since it is come
Without
in the-
service.
I will mail it, my lord. I will mail it today itself. I will mail it.
Lordship, may I be permitted to submit a lordship?
Since already there is a
Your letter is sufficient. You send a letter, advocate's letter.
at that I have served him
Then
in.
they will not proceed. The strength of advocate's letter, you have to consider.
But when the trial court is not accepting that unless stay order is there, he will be. Because of that only I come before this honorable court, and this honorable court has granted stay.
Lordship, may I submit a lordship?
Wait, sir. Let us understand.
59, then?
Yes, my lord, 59. Even before the.
Yeah, just let us go through it.
My lord.
Till the disposal of the application for setting aside the award.
My lord, this
So
order.
the execution was stayed till the disposal.
My lord, on 19th, what happened, my lord? On 19th March, I have produced this order before the London trial court that Honorable High Court has stayed the proceeding. On the same day, the trial court has disposed my 34 petition, my lord.
Because your lordship, this 34 application has been pending before the Honorable Additional District Court from 5 hours.
That when was it disposed of?
The 19th March. I produced this order on 19th March to before the trial court. On the same day, the London trial court has disposed of my 34 application. That
And when was the next date fixed?
28 execution cases on 28 April. April.
On 29th, your lordship.
9th April.
Lordship, on 19th, it was there for passing orders. It was reserved for passing orders, so the order was passed. In the meanwhile, they took the order from this court that it will be stayed till the passing of 34 execution. But 34 order was reserved for the last 2 months. Your lordship, when look at the order.
During this period, the circuit bench will not be available.
Yes, sir.
Circuit bench is coming on June. So you don't take steps for execution during this period.
Lordship, we have already taken the steps for execution. The additional district judge has.
29th of April, we are told.
Yes.
Yes. Yes.
They will pray for an adjournment. Don't oppose their prayer.
But your lordship, the 34 application has already been disputed and execution has been pending for the last 5 years, your lordship.
Then you first of all, you don't know. Second, you say that you want to say something. Both cannot run together. Either you take responsibility or you do not appear.
No, your lordship, they will serve the copy on us.
Now they will serve the copy upon you. 29th is the date. What is the last date of the circuit? So it has to 29th April is the date. So if you say that you will take for you will not insist for execution on that date, matter will be deferred. Very good. Otherwise, you have to consider this prayer. Make up your mind. Will you oppose the adjournment or not? Tell us. কি বলবো? ওই ডেটটা misdirected ছিল। Then what were you doing from 19th of March? You are sleeping. Today we are on
20th.
huh? 20th March sleeping.
I have obtained for certified copy, my lord, within,
Without certificate copy, you can proceed.
I have filed certified copy. my lord.
19th March এ apply করেছিল।
So you have received the copy on 1st April,
My lord, thereafter,
and you have been fooled on that day.
no, my lord, it takes time, my lord, for sanctioning from the department.
Then what can we do? You have not completed service. You have filed the appeal, though you got the certified copy on first.
My lord,
So how much indulgence can we give you? And this award is pending since when? We are directing you to
Only-
complete service, it will appear before the next bench, you pray for an adjournment there. কি বলিস?
my lord,
and
some
Mr.
interim order may be, limited order may be given,
No,
my
no,
lord,
change it.
next day.
Mr. Shivbala,
Since,
you are appearing from where?
Orissa,
Appearing from Odisha, Lordship.
but he is appearing in the trial court also.
digital India.
They are coming physically.
সেটা আমরা বলবো। He will complete service and we are keeping it on the next date of when this circuit bench assembles, it will be.
It is expected that is.
My lord,
Request করে কোনো মানে।
my lord,
You cannot complete service by tomorrow also, Mr. Shivbalan, otherwise you could have kept it tomorrow.
I have sent it by WhatsApp, my lord, I will send it by mail also.
This is not,
Scanning.
why we should accept all these things.
When you have got sufficient opportunity, you should.
Answering our acidic BGM, the service of the stay application upon the respondent is not complete. In view thereof, list the matter for further consideration on 10th June 2025. Before list the matter before the next available circuit bench on 10th June 2025, subject to the convenience of the honorable court. Stop. The appellant is directed to complete service of the stay application upon the respondent in the meantime.
Obliged. Obliged.
Item 5, the City County to open the.
obliged, my lord.
Sent, had contacted Mr. Bharat Bhushan by the
Mr. Shivbalan,
My lord.
what instruction do you get from the government like that? You have to move the government.
My lord.
Why such belated communication?
Till 10 days, my lord, I have filed. Till 10 days.
10 days means 24 hours into 10. It is
My lord, 10 days, I have.
Yes, what is it?
My lord had directed us to get in touch with Mr. Bhushan. So my lord, Mr. Rakesh Kumar wrote to Mr. Bhushan. Mr. Bhushan has also replied on mail saying that I told junior advocate to fix matter for next circuit, he will appear tomorrow. But today, my lord, nobody is here. But in view of this email, my lord may record this and send it to the next circuit. I'll give a copy of the email, my lord. Email sent by
You're appearing?
No, my lord.
Mr. Rakesh Kumar and response by Mr. Bhushan. Kindly see. Third page. two notices were given, one on 5th April, then 8th April. And then, my lord, on the third page, Mr. Bhushan has responded. In fact, he responded before also. No?
Who is the junior advocate, sir?
He's not said who will be the. First, he said he'll ask client to take measures. Then, lastly, he has said he'll ask junior advocate to appear. But nobody is appearing.
Pursuant to our earlier direction, the learned advocate on record of the rest
Yes, we'll do that. Items.
Sir, I have sir, I have submitted my reply.
Today,
Uh,
just like 3 a.m. in the morning, my lord, reply has been served, my lord. Let it be fixed for hearing in the next circuit, my lord.
no, sir, that this is an urgent because the 14-year-old boy died. There are 4 deaths due to the unfit vehicle which has been used. And now they are asking for next circuit because the matter is not being listed for two dates. The last 2 dates because the court is, and if it is postponed to next circuit, then it will come after May.
His reply earlier, he has taken repeated extensions.
Sir, I have not taken any repeated extension. I have submitted the reply. They are delayed. They delayed to submit the affidavit in opposition.
try to understand your interim order was considered on 7th February.
Yes.
Grant any interim order to you. For directed order, we will hear the matter on merits. Now you have used an affidavit in reply. We shall record that. And you have not served upon the respondent number 2 also. Mr.
Sir, I have served them.
Please try to understand. If the service is received by them today at midnight, how can they call their officers and take instruction? And your prayer is that they should not ply vehicles which do not have any fitness certificate, do not have any insurance. They cannot do so. You are absolutely right. But the issue needs to be thrashed out on affidavits because they will be saying that these are my fitness certificates unless there is those documents come and a substantive hearing is made. We would not be able to grant you the said relief.
Sir, I have in the reply I have submitted a document or downloaded from the Bahan app that the vehicle in question don't have fitness.
Disposed of Mr. Pal. We cannot pass any entry order today. You have to finally disposed of. You, have you physically filed the copy here?
No, sir, I have sent through mail to the mail ID of registrar.
Department, মনে এসছে নাকি? Have you sent it by mail to our department?
Yes, sir, to the registrar.
To the
Earlier also the High Court granted me permission to file through online.
right. All right, let us see. Yes, sir.
So,
It has not reached our office, Mr. Pal.
Sir, I have sent the mail in the sent option. They said that it has already been delivered.
High Court registrar will take printout, my lord. Can it?
That is the unapproved.
Mr. Chakraborty, he's a litigant appearing in person.
No, and seasoned litigants, hundreds of cases.
Maybe you are also a seasoned.
Not seasoned as him, my lord.
He is a seasoned litigant, you are a seasoned advocate. So, hard Mr. Paul learned, hard Mr. Paul, the petitioner appearing in person. Stop. Mr. Chakraborty learned senior advocate appearing for the respondent numbers 1, 3 and 4 submits that a copy of the affidavit in reply has been served upon him yesterday.
Today morning at 3 o'clock.
Today morning. But the
Email. Email is served to advocate on record at 3 o'clock in the morning.
Okay, submits that a copy of the affidavit in reply has been served by an email today morning. Mr. Kormukar learned advocate appearing for the respondent number 2 submits that no copy of the affidavit in reply has yet been served upon his client. Stop in view thereof, list the matter for further consideration.
Sir, this matter can be fixed on Monday also, sir. 14th.
It's available in circuit bench on 9th June 2025. Subject to the convenience of the Honorable Court. Stop. Mr. Pal is directed to complete service of the copy of the affidavit in reply upon the respondent number 2 in the meantime.
So the matter can be fixed on Monday also, sir, because this is an urgent matter.
Circuit, Mr. Pal.
Okay, I understand, sir, but the youngest one who died is just 14-year-old, is a school-going boy. Sir, I am paid. It's pained me because I am so aware. Sir, this is.
Mr. Pal, it is a very unfortunate incident which has appeared that we understand, but as a consequence of that, if they are not cautious, they will have to suffer the consequences. Today the matter has been kept. Moreover, this prayer was made on 7th February 25. The court was conscious about this thing.
Yes, I understand.
It was not ready. You, in the meantime, you serve complete service upon this respondent number 2, and we have kept it on the first day of the circuit bench. Yes, next.
Item number 7.
Paperbook is filed.
Oh,
My lord, the paper books have been filed, my lord. This matter will take time, my lord. I don't think it
so
can.
you do have the time. What is the problem?
My lord, this will voluminous matter.
This way, motions are completed.
No, this
Most majority of the hearing matters are kept pending. Unless we get assistance, it will go on pending in every circuit bench. It becomes embarrassing sometimes.
actually this matter has come upon remand from Supreme Court, my lord. So that I have to take instructions also from the client.
You have to have been, you have to have obtained such instruction in the meantime.
Very well, my lord, may I have it. I'll argue tomorrow, my lord. My lord will keep it.
That is a very good proposal you have given. But had you been on this side of the bench, you would have appreciated that how difficult it is
No, no, I
to take
appreciate
things
it.
in mind and go back to the main island and deliver the judgment.
My lord,
You ought not to have made such a submission.
I apologize.
Hmm.
My lord,
First of all, if you have to run after the advocates that please complete the hearing, it becomes a very, here are 7 matters before us, 3 matters you have taken an adjournment on this plea. If I am not wrong.
my lord, usually, my lord, I don't take, my lord, but the problem is, my lord, I'll assist, my lord.
Whatever may be the problem, but you cannot insist upon the.
No, my lord, we'll assist
No.
to the extent.
Just because,
My lord, I will
this is
assist.
the problem.
My lord, I'll assist, my lord. Whatever, to the extent possible, I can assist, my lord. I'll assist.
Yes, let us see what is
If
the.
you want order, my lord, I can show him.
সব বড় ম্যাটার সুপ্রিম কোর্ট রিমান্ড করলো সেই জন্য পিপিটি নিয়েছে।
What is the matter filed against an order dated 12 June 2019, passed by the Central Administrative Tribunal? Yes, please.
Yes, what is the matter?
The fact is that on 5th of March 2011, an FIR was initiated for with regard to leakage of CBSE papers. I was arrested in the said case. The moment I was arrested within a week, I was dismissed by service by invoking the provision of Article 311 2B of the Constitution.
Oh,
My lord, I challenged it before the court of law. The court set aside the said order saying that it is abuse of power by you. The moment the court set aside, my lord, on 24th of,
you are working as?
I was working as assistant sub-inspector in police radio, not in executive police
Who in police?
radio,
All right. Yes.
not in executive police radio. Now, my lord, subsequently, the tribunal abuse of power by the authorities set aside the order, said that you can pass a speaking order. Now, my lord, on the basis of that, on 24th of June of 2014, I was reinstated in service, and on 26th of June, once again I was dismissed from service
Without any proceeding.
without any process.
And any reason?
Challenge it. The reason has incorporated, they passed a speaking order also, saying that once again we are invoking and dismissing. We challenge it before the tribunal. I challenge it before the appellate authority, I'm sorry. In both the occasion, I filed the appeal before the statutory appellate authority. Appellate authority mechanically affirmed the order of the disciplinary authority. I challenge it before the tribunal. Tribunal this time set aside the order, saying that this is absolutely abuse of power. They challenge it before this court. This court affirmed the order passed by the tribunal. But my lord, while affirming the order, the court has wrongly written that in the same proceeding an order was passed earlier by this court. This was wrongly recorded by the High Court. So that was not in similar proceeding, in an earlier proceeding that order was passed.
What order?
Earlier, my lord, earlier also he was dismissed from service by invoking 311 2B.
So that was said
In another case,
against you.
against me, in another case, 2008, in the year 2008.
You are in the habit of doing these things.
So this is the allegation. I have never been convicted by any court of law. No witness was hostile at any point of time. I have been, my lord, once a person is that, one after another cases were initiated. No, my lord.
When did the Supreme Court say?
No, my lord. In High Court, the High Court has wrongly recorded that in the instant case, earlier also a similar order was passed, though that order was passed in the year 2008. When the matter travelled to Supreme Court, the Supreme Court found that this similar portion that is wrong. My lord, I appeared for the respondent before the Supreme Court also. The Supreme Court has asked me and the other party, and I have submitted this. It's a wrong recording. It's a wrong recording. It ought not be similar. It was a wrong recording. And because that was in the earlier proceeding. Because year also, my lord, entirely changed. That was 2008. This was in the year 2020.
Then what did the Supreme Court?
Supreme Court remanded back. I requested the Supreme Court kindly dispose it on merit before this. Once again, I have been relegated unnecessarily. Supreme Court said you will be benefited. So once again,
Your benefit.
my benefit, I will be benefited. I said, my lord, let it be disordered because I was arguing, I placed all the facts. I said, my lord, it's absolutely abuse of power.
Now tell us, in the other proceeding which was erroneously recorded, in that also termination order was passed.
Yes.
So what has
11(2)(b).
11. Now, are you suffering the consequence of that order still date, or that has been set aside?
No, my lord, after that, no disciplinary proceeding was conducted by them.
No, that in the
That order was set aside, my lord.
that order was set aside,
That reached its finality,
and you were reinstated.
reinstated.
So now afresh this allegation.
Yes. And my lord, the criminal case which has been initiated, I have been acquitted from the trial court, I have been affirmed by the High Court, and the Supreme Court has not interfered with this order.
When was the termination order?
Termination order was passed on 16th of March 2011. And my lord, the court has repeatedly, my lord, the court has passed an order in 2014. Well, today also there is no stay, my lord. There is an order to reinstate me in service. They have not reinstated me.
My lord, we have stated in the.
The first charge or a similar charge was made against you, leakage of paper.
No.
That was something else.
That was with regard to that in a restaurant there was some assault. That was.
My lord may have writ petition, my lord, page 13, paragraph 31, my lord. We have narrated, my lord, it is stated, my lord, this is page 13 of the volume 1 paper book. It would be clear that from time to time, respondent was involved in one or the other criminal cases from sequence of events. It is not plausible to conduct full-fledged disciplinary proceeding against the authorities had no alternative except applying provision of Article 300, paragraph 31, page 13 of that volume 1. That from the entire facts, it would be clear that from time to time, respondent was involved in one or the other criminal cases. From sequence of events, it is not plausible to conduct full-fledged disciplinary proceeding against the respondent. Authorities had no alternative except applying provision of Article 301(2)(b) of the Constitution of India. Before the disciplinary proceeding could reach to the stage of inquiry, which was initiated against him on 6 June 2005 on the charge of commission of offence under 489B IPC. 489C 201 of the IPC, the respondent was involved in another criminal case on 8th April 2007 under section 397, 504, 506, 34 IPC. As he was involved in the criminal case, he was dismissed from services on 12th April 2007. Litigation challenging the said order proceeded up to 18 December 2008. Before a regular departmental inquiry was initiated against him on the said date and also on 18 December 2009, the respondent got involved in another criminal case on 29 June 2007 under section 12(1)(b) of Passports Act 1967. On 5th March 2011, he was again arrested in connection with a criminal case under section 406, 409, 420, 468, 470, 120B, 34 IPC. He was accordingly dismissed from services on 16 March 2011. It is a fact that he was acquitted from criminal case registered in 2007 on 30th March 2011. However, in the other criminal case of crime number 13 of 2011, he was acquitted on benefit of doubt. It is for the said reason that the authorities refused to interfere with the penalty imposed upon the respondent. The authorities submit the respondent was attached to a disciplined service and he cannot be permitted to continue with the same having such criminal background, especially when he was acquitted on benefit of doubt.
So kindly come to the previous page, paragraph 31, which you have just read.
Yes, ma'am.
The authorities had no alternative except applying the provision of 311(2)(b) before the disciplinary proceeding could reach to the stage of inquiry, which was initiated against him on the charges of such and such. Respondent got involved in another case. So you also believe that there ought to have been a regular proceeding. Your statement says so. That before we were minded to take this step, but we could not do so since he got involved in another matter. How does that prevent you from initiating a disciplinary proceeding? This is your own admission, affirmed as true to knowledge. Why should we not summarily dismiss your appeal? The person who has affirmed this is Mr. Jai Kishan, and he has affirmed paragraph 31 as true to my best of my knowledge.
But my lord will, that earlier part is also there, my lord, that
That dilutes the statement, you mean to say.
kindly see, my lord,
This is over enthusiastic.
So against you, fake currency notes charges are there.
Yes, madam.
Fake currency.
Those all cases were acquitted. My lord.
benefit of doubt.
311 2B, my lord.
The procedural aspects has not been.
You conducted disciplinary, my lord, what the High Court has said, you conducted disciplinary proceeding, throw him out of the service, but how you can do this?
311,
Do you agree to that?
I am agree, my lord, let the disciplinary proceeding be conducted.
Then you will not be reinstated. You will be continued.
Already there is an order of reinstatement by the tribunal. Already there is, my lord, may kindly see, 2014 court passed an order, till date I was not reinstated.
You charges against you are habitual.
My lord, there is no stay order passed by any of the court. Neither Supreme Court has passed any order, nor in the Supreme Court they have prayed that let the order of the tribunal be stayed till the disposal of the appeal. Nothing. At no point of time they
Tribunal said what?
tribunals have to reinstate, set aside the order. Tribunal set aside the order, my lord. Firstly, on 24th of June 2014, and secondly, my lord, the tribunal passed an order on 12th of June 2019.
that order, let us, if your lordship permits, the tribunal's order, if I can go through, my lord, once. Page 319. That is the order impugned.
Yes, my lord.
Let's go through the entire chain of 318.
Yes, I am narrating the fact that despite of an order on 2 occasions, despite of the order of the High Court.
He's not in a position to assist a student.
My lord,
I'm very sorry, my lord. I'm really sorry. I can only try, my lord. Because Mr. Kumar is on the other side, my lord will appreciate, my lord.
His next side. Take the order. Sure. Bhushan.
Direction was given upon the respondent authorities
Hmm.
file an affidavit on one point regarding the status of the subject matter. A direction was given and the date completed on 7th of April. Till date, the respondent authorities have not filed the affidavit. Acts have intimated the authorities of
আচ্ছা মনোজ একটু শোনো।
Saraswati Mandal, wife of Mandra Mandal, stating post expiry of her husband that the above said energy meter connection is no longer required and the same may be dismantled to avoid unwanted situation in the future. In view of the above request, the outside premises was inspected on 24/2024 and 29/4/2024. On both the occasions, it was observed that the house was locked and abandoned with nobody residing in the premises. Accordingly, as per the request received from the wife of the deceased, and on settlement of the final bill receipt number so and so, the energy meter was dismantled on 15/5/2024. Further examining the instant complaint letter received from Sri Sanjeev Bandar, so and so residents of Netaji Nagar, and on inquiring the matter from PRI member of the said panchayat, it has been revealed that the matter is purely family dispute, wherein late Manindra Mandal and the late father of the complainant were brothers. The complainant is therefore requesting for resumption of electric connection at his house, which stands on the land of his uncle, late Manindra Mandal. In view of the above highlighted facts, it is submitted that the above department has no objection for providing the electric connection at the house of the complainant objected to the condition that he shall apply for the first connection with all necessary documents as per prevailing JERC regulation in force. Your Lordship, actually here what happened, Your Lordship, in this case, the respondent number 3 and respondent number 4 disconnected the electric connection from my house. And without no notice, nothing was given, no opportunity of hearing was given. Your Lordship, one thing is very much clear from the version of the respondent number 4 that I am having the house in the land of the uncle. And this thing, the respondent number.
Where are you residing? Are you residing there?
Yes, Your Lordship. I am residing there. And
Then why it is under constant lock and key?
no, it was not the, it is Your Lordship. For that also I will prove it, Your Lordship. It was not.
So this is not the forum to prove that.
No, actually, Your Lordship, I have the document.
Sir, try to understand what is the, if you are in settled occupation, if you are in continuous settled occupation, question of getting electricity will arise. That has been provided to you by the order itself, that you make an application, it will be considered. But here what has happened, it is an allegation on the part of you that I am staying there, you have not given me notice, you have. This is your argument. To see when was the disconnection? See,
It was
15th of May 2024. So have you been with the family? Will you have wait for 3 months to make a complaint? You can make the complaint on 9th August 24. Disconnection was in May 24. Very good. Now let us see, ascertain what the records say. Yes, Mr. Mishra.
The parents also given no objection to disconnect the.
Just a moment.
Mark it, right it.
Where is your notice that you went there for inspection?
Report, just now my senior has read.
No, that is the order passed.
No order, it was communication between the junior engineer to assistant engineer.
So then it says that you went to the spot on 2 dates. So you are required to give a notice, no?
But nobody was residing there. And the meter is affects outside the house, not inside the house. So upon the application, we have disconnected the meter from the house.
No, outside out, inside out, what difference makes it? It is the connection which is to be given to the house.
But meter is affixed in front of the house.
Achha, show us that the meter was in running condition. Was it being utilized? Where do we find that?
Number 40, I 40.
39%. Minimum charges were there.
Madam, wait, madam. You are already in a favorable position now. Huh? Yes, page 40, Mr. Mishra. Yes. Consumer a month, year.
35 all together.
3435 was the old meter reading on date. What is the date? This is the month of August.
Date, that's it.
August
2023. Then
September, October.
November, December, January, February, March, April.
So this goes against. You are now caught on the wrong foot. You are caught on the wrong foot.
See here, Logic, the meter was actually not working. How the department was taking 153 rupees unit consumed. Kindly see, it is there mentioned.
Where?
Unit consumed. Kindly see your Lordship. New reading, old reading. And thereafter it is 60. Unit consumed is 61. If no one was residing, electricity was not in use, then unit should be the 0. And they should use, they should take the 24.
Unit consumed is the same in all the months.
Yes, Your Honor, because they were taking, it was not working, so approximate units they were taking. And the amount was, Your Lordship, 153 rupees. It is not the minimum amount, Your Lordship. They were taking an amount of rupees 153, 155. Kindly see, Your Lordship.
Mr. Mishra, how is it done? This is a unit consumption which is recorded by you. Unit con. No, what is the meaning that if the reading, no further adjournment. Reading, you tell us if the reading is unaltered, why you are charging on the unit consumed?
Lordship, new reading may kindly be seen, Lordship, prior to that, new reading, old reading.
Same. The unit.
This I do not know, Lordship. I could not take instruction with regard to this.
Your Lordship, I was residing in that house, I have the.
You ring this up, you ring up this officer and tell me.
Can it be passed over for 5 minutes?
Yes. You take instruction and explain this to me. Pass over. Yes. You take your record if you find any reflection there or not for you to assert. It to onake dao. Pass over. Pass over.
Item number 2. Occupancy plus 185.
Lordship, I am appearing for the recommendation.
Ki dekhi? Who is for the petitioner? Anil Chakravarti. He is not here.
The grant of electric connection.
He has made an application that has not been disposed of.
Actually, he has served me copy, Lordship, not through the department. I have inquired from them. I have asked them to bring the instruction whether this has already been allowed or it has been rejected.
These people file the matters and go away. 3 matters of Anil Chakravarti. Pass over. That is also Anil Chakravarti.
Item 4. Item number 5. WPA 172 of 125.
আচ্ছা ফাইল করছে যখন রিটার্নেবল ডেট দেয় ফাইল যখন করে রিটার্নেবল ডেট দেয় না যেদিন যখন রিটার্নেবল আছে চেনো তুমি এই অনিল চট্টোপাধ্যায়কে এই তো নেই So we could have disposed of this application asking you to consider and take steps. But where the petitioner is not here, no? Pass over.
As per direction, I have already filed the report. And for the additional matter, I had applied for grant of electricity connection. The application is appearing at page number.
Where is the report, Mr. Mishra? Oh, I see. দেখি একটু দাও। You have got a copy? Report. What have they said?
They have inspected the property and subsequently they have found out that I am in the possession. Estimate was given, but subsequently one letter came from some third party. He stated that the land is not going to be government land, it's a private property.
Hmm.
So the junior engineer had made a letter to the Tahsildar to conduct a demarcation and find out what is the factual error. Now the Tahsildar had conducted the demarcation and subsequently found that in the private property there is no house, only in government landed property there is house. So, but despite of the same, Tahsildar has not communicated the report to them. For that same reason, electricity connection is pending. They are not supplying me the
So, where from did you come to know that the Tehsildar has?
Yes, my lord, in my writ petition, I had page number 22. Is the report of the 21, my lord, prior to that, the application which was given by the assistant engineer, that was the layering portion, my lord. Verify and identify the survey number 170/P and 535. On 8 November 20.
So you sought for connection in which plot?
170/P.
And what is this 535?
535 was the objection made by some other party stating that
No, the complainant claims that the place where connection has to be provided is survey 535.
it was the allegation. Subsequently, page number 22, ma'am. It's the report.
Verification.
Verification of survey number.
Yes, place it.
Yes, my lord. Reference number RD number 6510 11/24, subject verification of survey number 170/P and 535 Chuldari village.
No, the complaint against you was what? The applicant has applied under encroachment. This is assistant engineer is writing.
Yes.
Case was forwarded to forest department for the about land status. Forest department in their letter confirm land does not fall within video memo. The connection was under process based on
Declaration.
Sir, now a complaint.
About authenticity of survey number mentioned in affidavit, that is 170/.
So the authenticity of survey number is 535.
170/P. Allegation is that 535. Is subject.
No, survey number mentioned in affidavit is 170, that is yours.
Yes.
Well, the complainant claims that the place where connection has to be provided is in different survey. Now what he is owners.
Survey number 170/P and 535 at Chuldari village. With reference to the above stated letter, a request has been made received to verify factual position and ownership of survey number 170/P and survey number 535 situated at Chuldari. As per revenue record, survey number 170/P, area 168.91 hectare situated at Chuldari stands recorded in favor of government revenue department. And survey number 535, area 340 square meter, classified as outside situated at Chuldari, stands recorded in favor of Anupam Sarkar, son of late Mukul Sarkar. As per local inquiry and field inspection, it has been found that a house has been considered and is occupied by a tenant bracket unknown on government revenue land at survey number 170/P Chuldari. In contrast, survey number 535 record in favor of Anupam Sarkar does not contain any structure. So there is no structure in survey number 535 itself. So how I can claim electricity connection over the sector?
So they are saying that as they have not received any formal communication from Tehsildar.
But for that reason, they are not paying. And they have even provided the estimate also.
Yes,
Page number 9.
To the extent that.
We will record this Tehsildar's report.
Because this is not certified copy, it is. They have taken photographs of this. it has to be submitted before the Tahsildar and thereafter Tahsildar will give his finding.
Further from there, affidavit also an inspection was commenced by their side, and they have also found that we are in the government.
Who is appearing for administration?
For all the respondent, they are.
Then why you are not sending this letter?
For Tahsildar, I am not appearing. Tahsildar is not a party. I believe. But what Tahsildar is not a party to this proceeding.
No, Mr. Mishra, why you are disputing the
This part, Lordship, because this is not certified one. If petitioner will provide certified copy.
where from he will provide? He is running from door to door. He is running from door to door. You give him connection. You give him connection. If anything wrong is decided, you then we will record that you will disconnect it immediately. Then.
Lordship.
Further from page number 6 of their affidavit which they had filed.
Hmm.
There also they had inspected on 15 October.
এই পেয়েছো রিপোর্টটা? ও আচ্ছা,
My copy.
দেখি একটু ব্যাপারটা। Yes, why? What you are?
The inspection report done by the electricity department.
Mhm.
Page number 6 annexure B.
Hmm.
Yes, my lord, as the inspection result. Point number 4, my lord. Inspection result, Branson J.E. Choldhary proposed date of inspection 15 October, inspection result. Clause number 3, my lord, remarks. Constructed a house on an encroached land near BSNL office, the house is in settled position as per report. R.O. Choldhary, the status of land is revenue land by letter number such and such. So the inspection was done by the electricity department.
What is this as per report RO? What is?
I suppose they have inspected with revenue officer.
Chaudhary means?
Choldhary was village of the concerned village. On 15 October itself, the electricity department had inspected and after inspection and finding the settled possession. They have estimated the cost.
I think we had done due to the objection filed by one of the advocates who is legal notice, so we have not renewed because if it is not in settled position, then again one litigation will come. We don't have any objection to provide.
And my page number 19 of the writ petition, the estimated amount which was communicated to me is also.
Yes, I am
Annexure P3.
Where is annexure P3 to the report, Mr. Mishra? P4 was. Where is P3 estimate?
That is the estimate, Lordship.
I see.
Page number 19 of the report.
Where is the report of the junior engineer? Inspection report of junior engineer is, that is page.
Annexure B.
Yes, take it down, Mr. Celia.
Number 7. I am applicable to India 2025.
Yes.
But if I have received the report, we have sent already the application which has been made by the petitioner, we have sent it to the Tahsildar for getting whether he is in settled position or not. So that is submitted.
Tahsildar is a party here.
No.
You have made Tahsildar a party? No.
Generally, you don't need to make party with the Tahsildar, with the state engineer or engineer or.
Yes, tell us what is your matter.
I could take his correction on the 5 October 24. Okay. Page 12 P2.
Yes, then.
Till date, he is not applied the correction. Within one month, there is a mandatory that department will provide connection within 30 days from the date of the application, but he will.
Yes, Mr. Mishra, when have you sent it to the Tahsildar?
On 18th November. Her name is appearing in this.
18 November 24. To the Tahsildar for a report as to whether he is in settled position.
It is the government revenue line. Encroached government revenue line.
So, what do you do in cases where the Tahsildar does not take any step? What happens to your obligation to
But
give?
they are sending the report.
Pardon? They are
Tahsildar is sending the report.
no, this has been done in November 24. We are in April.
If you get that report, we will provide the electricity connection if they fulfill all the criteria.
No, under your licensee rules, is there any provision that you will send it for verification, and in the event no such verification comes within a stipulated time, then you will take steps. So then there is a violation on your part, Mr. Mishra.
Let me file opposition.
Opposition or electricity connection, what opposition you will find? Your only grievance is I am not getting. You conduct an inspection as you have conducted.
We cannot identify the plots.
You amend the licensee rules. Your licensee rules creates a statutory obligation on your part to discharge. Amend it that you add that rider till the favorable report comes from the Tahsildar.
Yes, circular is there, Lordship.
Show us. Please show us the circular. Have you brought the judgment of this Pune Dam which is referred to? Sir, you have to wait then. There is a circular.
This circular is not applicable in my case.
Why?
Because as per JERC, there is no such term and condition. I repeat, we have intended to avail power supply in accordance with the clause 3.5 and 3.6 of JX regulation 11 electricity supply code within 1 month from the date of the application.
Where you are reading?
From the application itself,
Page,
page 2,
page 12.
page
Hmm?
12. One clear.
Hmm.
Under to the estate engineers, provision 3, electricity department for Blair, sir, madam. We hereby intend to avail power supply in accordance with clause 3.5 and 3.6 of DRC regulation 11 of this 2020. Then electricity supply code within 1 month from the date of the application.
Where you are reading, sir?
Page 12 or online application.
You gave page 12, this one. You people don't check up page emission and start extempore submissions.
Yes, yes.
Still. Page 10 is your read. Five চেকও করবেন।
After it is with the Aadhaar card and the-
Yes, we are going through it. We have enough time. Tell us, sir. We will make the pagination for you. No seriousness, nothing. Client comes, file it. Don't paginate anymore. The judge is there now, he will paginate for you. Don't worry. This is the respect you show to us. I can measure the respect which you have. These are to be thrown off with cost. The matter of as if you are purchasing a particular commodity from a shop room. See your conduct. Neither you apply your mind, neither your junior does. So let's go to court, file and 35 paisa page court fee and let us file it. Sure. Let him find out which page he is referring to. What does this Punanam say? What does this Punanam say? Yes, sir, you are doing electricity matter. You will not have the judgment. We will have to find it out for you. Where is it?
It is missing, but maybe put me in my copy. My office copy.
Surely?
This application is existing in my office copy, but there is missing.
Doubt is. So, haven't you conducted an inspection on the basis of the application? You must have conducted, no?
No, but we have forwarded it to the Tehsil. After receiving the application, we have forwarded.
But in the other case you conducted, the earlier case.
Yes, sir.
So,
But in this case, we have already sent to the Tehsildar after receiving the application.
hmm.
We have sent it to the Tehsildar.
When have you sent it? 18th of November.
Lordship.
Yes, you read the connection. I will incorporate if the declaration clause, and if it is found that it is not a government revenue land, you will be at liberty to disconnect the connection. Yes.
There is available provision is also there. But no order has been passed, so he cannot appeal, so I am not making that for you.
The present application has been preferred, alleging inaction on the part of the respondents to grant electricity connection to the petitioner. Mr. What is his name? Siddiqui. Mr. Thakuran, the advocate appearing for the petitioner, submits that the petitioner is in settled possession of a government revenue land. Settled government revenue land bearing survey number P/1 measuring 2000 square meter, situated at such and such paragraph 3 में बोला हुआ है bracket herein after referred to as the said land. He is residing on the said land upon construction of a house building. Stop. Annexing all relevant documents, including an affidavit and a declaration, including an affidavit and an undertaking. The petitioner submitted an online application praying for electricity on 5th October 2024, praying for electricity connection. Your original application must be here with the file. Now to রেখে দাও, after I sign the order, he will take it. Yes, next.
Number 8. WPA 124 of 2025. This application has already been rejected.
Rejected. Have you communicated?
Lordship, it is available in the internet, in the portal of the department. I aware of this order. It has been rejected due to not ration card and Aadhaar card. But I have annexed the merit petition on the two documents. Page 12 and page 13. Aadhaar card, page 12 and 13 is ration card. And only on this two ground, but when the ration card was issued, may kindly see Lordship, date of issuance of the ration card.
Yes, tell us.
It is annexed in the writ petition, Lordship.
Yes, what is the date? Page 12?
22 November 2024. He has obtained this
Date of
ration card.
Yes.
And he has applied prior to that on 2nd April 2024. It is duplicate. My original has used, so that's why I obtained duplicate. Issuance date is duplication, not the original. At the time of filling of the application, it was not. Yeah. Now I will produce.
Then what is the procedure, Mr.
He
Mishra?
has to reapply.
He has to reapply.
Two documents has to supply. I will supply.
No, you said you make a formal, we will record that you made an online application without annexing the ration card, because then the original was not with you. You're saying that undertake this card is where do we find that your card was lost and this is the smart card which has been issued? Where is your old card?
There was no route that Aadhaar card and this card may be.
Do you have a ration card or not?
Yes.
This is of 2nd November.
It is a duplicate ration card.
Where do we find it's a duplicate ration card?
A original card is, so I have got this.
Where do we find that story? Have you said that in your petition?
No.
Then where from did you come to know? Extempore you are saying. My client did not have it now. Where is the line you have written? Is there any, suppose you can process now on the basis of this ration card, this 22nd November?
On portal, it has been rejected. So he has to make a press application enclosing all these things. They will consider that.
So what is the reason for rejection? What the necessary? What is the remark which has
To provide the electricity connection.
has not been annexed along?
Yes. Submit either ration card or electoral ID card, mandatorily having the same address as proof of occupancy of the premises only for the purpose of releasing electricity connection.
Very good. He will produce these two documents before you.
Since already in portal it has been rejected, he has to apply a press. That is the difficulty. This is the rejection order.
Now, in the previous matter, you showed me the application, that 5th of December, previous matter, that was an online application.
Yes.
The present writ petition has been preferred, alleging inaction on the part of the electricity authorities to grant electricity connection to the petitioners.
Number 9. Here also, application has been rejected.
Same round.
Same.
But you don't see, I have annexed Aadhaar cards and the Rasan card. Yes, so this.
Yes.
But the
Next in the rate petition, but not along with the form. They have not uploaded it.
you withdraw this petition and apply now. Why you are?
The two, document I will.
I don't know. That will create more confusion for you because that was online. Now today you will submit offline. Again, it will be harassed. I don't know whether the website is.
Back to this application.
They will not keep it open because this will generate thousands of litigations.
Again, I will. Again.
That is for you to talk over Mr. Mishra over a cup of coffee.
So you have to take department will be directed and the two documents be accepted by produce.
That will not create any issue in your favor. I don't know. Can that be done? Then I will direct so.
Online.
Then I will. Apply.
Then do you want an order to be passed or do you withdraw this application? On the prayer of Mr. The advocate appearing for the
Number 11. Number on 94 of 95. Lordship here, it is a forest plan.
oh my God, that has been confirmed.
Yes. I have received the report, Lordship. I have not received the copy, Lordship. I will pray my learned brother.
Oh, he has not.
Let it come tomorrow.
No, Mr. Mishra, then you produce that.
No,
No.
in this case, it is not forest land. It is not forest land. Let him supply a copy to me so that I can take instruction.
Not today.
Number 12. Occupancy 204 of 95.
12 to 16, I have taken. I'm praying for withdrawing this petition because I have mentioned only 14 square meters. I have done the mistake. So I have withdrawn it and filed it. The area which I have mentioned, that is wrong. From 140, 200, instead of that 14 point. From the beginning, it is mistaken. From the affidavit, it was affirmed. For the electric purpose.
The quantum of land is wrong. On the prayer of Miss Milan, the advocate
In item number 7, my lord, and for the rate petition, my lord, here I had applied for the electricity connection and they had rejected my application on the ground that page number 19, my lord, annexure P3. Let me take it.
No, you will, we shall give it to you.
Remarks, my lord. Page number 19, annexure P3.
Yes.
Yes, my lord. Page number 19, remarks, my lord, as per JERC regulation 2018 clause number 5.30, a no objection certificate from owner of the premises is required. Now I am an encroacher. They are asking that I have to obtain no objection from the Tahsildar. Now, that specific point has been already decided by this honorable court, it is at annexure P4. I annex the judgment. And the relevant will be, my lordship, page number 26. I am allowed to give you my lordship.
Which one?
Page number 26.
Yes.
A provision of clauses 5.29 and 5.30 indicates that the same merely provides modalities to get electricity connection. Clause 5.30, clause 7 stipulates that the applicant is required to produce an objection certificate from the owner of the premises. However, the heading of the clause 5.30 is that any of the documents mentioned thereunder shall be considered as acceptable proof of ownership or occupancy of premises, out of which no objection certificate is only one. Hence, the argument of the response that non-furnishing of no objection certificate vitiates the right of the applicant to get electricity connection cannot be accepted as tenable in the eye of law. It is well settled that even if the person of a person is tainted by illegality.
So you have furnished other documents except no objection certificate. So that no objection is not a requirement now. So they have rejected it.
On that ground. It has been already decided.
Then what has been the ultimate direction?
To grant the electricity connection. Last second, page number 29, by directing the responsible authorities to give electricity connection to respective petitioners, that is subject to compliance of all former otherwise by the positively.
Yes, Mr. Mishra, I set aside, I relegate to you.
Let it come tomorrow.
যে এইটা যখন উনি ইলেকট্রিসিটির ইয়েগুলো দেবে না তখন আমাকে একটু এটা পাঠিয়ে দেবে। This is item 70. Yes. Mr. Mishra, can you take that information?
Lordship, in this matter, I am for the writ petitioner. Lordship would remember in this matter, I don't have the right to ingress and outgress. And I have, in my representation, I have asked for a pathway from the settlement part which belongs to the government. And Lordship has directed the government.
Yes, madam, can it be done?
Ask for some documents pertains to form A, which states that the survey numbers which they have mentioned, it's recorded as footpath and one is recorded as road. So if you the revenue department will not do it. The PRIs and the panchayats and they do for the construction of road.
For the development.
For the development. So
No, that you cannot build the road. So what is the?
Though now they have made it very clear that that is a footpath, it could be used by yes. But the only point is, Lordship, it was not used for many years. So there might be bushes and all. So if we get the right only to clean up by itself, we will do by itself. The path is there, Lordship. It should be a movable path, no, Lordship. It should be a movable part.
This submission itself creates suspicion. Because you have not made this submission yesterday.
Lordship.
Now, when this
Lordship
court
is
said,
right. Lordship
when this
is right.
court said that you please take the information, now you are coming and saying that I allow me to remove the bushes.
Lordship,
This
because-
creates suspicion.
Lordship, because we were not having the record, Lordship. As per the instruction, they said there was a government settlement part. So in my writ also I have mentioned the same thing, Lordship.
Who is stopping you to use that? They are not stopping you.
Lordship,
We will record that.
yes, Lordship, but the only thing is we should get the right to clean up.
No, sorry, that sir, I cannot do. Sitting here, I cannot decide.
Lordship,
How you
in that case, Lordship, in that case, kindly come to Regulation 104, Lordship, of the Andaman Nicobar Land Revenue Land Reform.
Yes.
Kindly come to the regulation, Lordship. Because they have submitted that it is a government part. So as per this 104, Lordship, if the Tehsildar finds that may an obstacle impedes the free use of a recognized
Wait.
Lordship.
Now you tell me the previous facts first. What is there? What is this page 42?
No, please submit, please, let me submit. 42 is the order passed by the Tehsildar, Lordship. When the part which the land we have surrendered, it was later occupied by a person who previously surrendered the land. So on our complaint, the Tehsildar in page 42 has passed an order that this is the surrender land and he has directed that party to evict the surrender land.
I see. Now thereafter he went for a civil.
Civil suit, Lordship.
So now your grievance is that since there is no possibility of an early settlement in that, you allow me to enjoy the government land.
Because it is a part, it is a register, it is not a government revenue land, Lordship. It is registered as a part, government part.
Achha, that is which is the survey number?
Survey number,
where is your representation to that effect?
Lordship.
Page 47.
Page 47, Lordship.
Yeah, just a moment. Just a moment. So there are 4 survey numbers,
Yes.
na? And what is your report? Serial number 6.
Recorded as footpath.
Footpath.
Serial number 14.
14 they do not want.
41.
41.
41 is a road.
Footpath, Lordship.
41. 41 is not a footpath.
Serial number 14, Lordship.
No, their representation says there is a settlement path of government land. The lands bearing survey number 18, 166, 163 and 41.
Lordship.
Oh, 41, yes.
Then the third page will have serial number 52.
Serial number.
Serial number 52,
Hmm.
survey number 163,
Hmm.
recorded as road. Thereafter, 54. Survey number 166, is recorded as footpath.
Yes. Now what do you say? Now where from that there are hindrance over that, where do you have said?
No,
Let that come.
when we
Get this order. Get this order first.
Lordship.
Thereafter you find that you are in spite of their admission as a footpath.
Lordship.
You are not being allowed, then you can make a representation and come back.
I've get. that could be given.
The present writ petition has been preferred. Seeking issuance of necessary direction upon the respondents to provide path from government settlement land. Name.
Petitioner, sole petitioner.
Lordship, average, this 61 point will come. Yes. I have asked them that, particularly that point only, Lordship. So they have said that this is average reading of the meter.
Your Lordship, not only this, your page 40, your Lordship.
40.
Page 40 of the. Your Lordship, page 39 also, kindly see the page 39 also, your Lordship. Page 39, your Lordship. Yes, your Lordship. Yes, your Lordship, this page 39 is the receipts, your Lordship. I was using the electricity and I was paying the electric bills, your Lordship, and I'm having the originals also, your Lordship. Otherwise, if I was not residing there, I was not using the electricity, how I will have this all documents, your Lordship? Yes, your Lordship, I mean, now.
You have, because why did you have to pay the meter?
No,
The meter was not in your name.
I was using the electricity, so that's why that I was paying the electric charges, your Lordship, because
So
which,
only from any document that.
yeah, it is there in the, it is a page 39.
39 what years?
It is, these are the receipts, your Lordship. Receipts, which I was.
22. These are the two receipts of 2019 and January 20.
Some more documents are also having, your Lordship. The only documents are, otherwise, your Lordship, how I will have this.
Then you file supplementary affidavit. Then you file supplementary because you have to be in second position. What document you have? Sure.
These are also the electric bills and the.
Which year?
It is since from the 2018.
When was the last payment made?
Actually, your Lordship, the petitioner of this case is Labour, your Lordship. They gave me only these documents up to the 2022. But they were paying the bills up to 24, they were paying, your Lordship. They were paying, your Lordship.
Sir, please try to ascertain. Settled proposition is, if you are a settled possession of the same, you will be given electricity. Now your grievance is that you have disconnected my electricity. Though it is changing, meter is reading in the name of your uncle, though you were deciding there, it was, you were utilizing the electricity. So now they go for an inspection. On basis of what? On the basis of the family members of your uncle. They give no objection and ask the mother, you file an application for cancellation. That is, they have done. Now you being the, after that was done in 2020, admittedly it was disconnected in 2000, May. You lodged a complaint after 3 months.
Can you come to the page, your Lordship? I will also show one more page, sir. Kindly come to the page 43, your Lordship.
What is page 41? You are this is.
Your Lordship, this page 41 is that, your Lordship, after disconnection, your Lordship, came to me and I filed an application for seeking the documents under RTI. These all proceedings were being done, your Lordship. This is not that after 3 months the application was filed. So I got these all applications, your Lordship, under RTI Act.
And thereafter, your lordship, I came before this honorable court, your lordship. This is in this way, the time was consumed, your lordship. It took the time, your lordship. It is not that they were, moreover, they are labor, your lordship, and sole earning member, your lordship. It is very difficult for him to leave the job and come further and approach. These all difficulties are there, your lordship. It is only the electric connection, your lordship. The right is there, your lordship. So it is my humble submission, your lordship. And moreover, the school going child is there, your lordship. Sufficient documents are there.
Say something which is there on record.
It is there, your lordship.
Where you are having school going children, you have written.
It is there, your lordship. It is at page 58, your lordship. Page 58, your lordship.
What is the survey number of this?
This 112, your lordship. The three survey numbers were there, your lordship. 111, 112, and 113, your lordship. I'm in occupation of all the three survey numbers, your lordship. This is not only one. Page 58 is the school document, your lordship.
Yes. What do you say, madam?
They are not in that information.
Where you are deciding? Where are you deciding?
I'm deciding on my own land.
On my own. You are not deciding this. You are not deciding.
That was an old house belonging to, it belonged to me. They are not at all the owner of the property. They are trying to occupy that particular property. For that reason, all these things they are doing.
No,
They
no.
are
How
not in
can,
occupation. That is the proof.
that is a disputed question, madam.
So that is a good question. Now, what I am submitting, so far as the meter was concerned, which was in my name,
How you even how you lose, even if the electricity is given to him.
let's make it.
No, no, apply address, you will object to it. Exactly. Your land, if he is in settled possession, you have to give it to.
The lordship documentary proof is there, authority is saying it's.
Suddenly an inspection. No, no, suddenly this creates suspicion. No, suddenly your authorities went and conducted an inspection.
My authority.
Also, there must be something 20th April. Let me see your record.
When an application was submitted to the authority, they went to the place. They found it is under lock and key. It is not used. Now, whether this honorable court, on what basis this honorable court will disbelieve that thing? There must be some material. Meter showing old reading, new reading same. Payment of electricity dues, electricity charges is the minimum one, 29 rupees, 160 rupees like that. How will you come to know that they are in possession? By obtaining an order from this honorable court, after getting the electricity connection, they will occupy the premises. That is their intention. Their
So
occupation.
who is in occupation now?
It's vacant. Hearth is there. It's lying in very old house. Now we want to enter into that. Due to the non-availability of the electricity, they are not entering into the premises. Once electricity is provided, they will enter into the premises. That is their intention. They left it long back because they knew that they are not the owner of the property. Let me file opposition, your lordship, dealing with this. I did not get the opportunity to file the opposition also. It's a motion stage.
The present repetition has been preferred. ওনাকে রেকর্ডটা দিয়ে দাও।
मनोज जी और एक प्रोवाइडर
আমার কোনটা আছে কিছু চলে গেল ওরা হ্যাঁ হ্যাঁ
Item number 2, WPA 166 of 125.
I am appearing for the respondent. Nobody is there.
2, 3 and 4 না
Lordship.
you have obtained instruction Mr. Mishra?
No, Lordship. He has served me copy. I will take instruction.
Let it be not today then
Lordship, let it go to the next circuit.
tomorrow we will let it go let us see it.
Lordship, Lordship.
Yes not today করে রাখো 2, 3
Item number 5, WPA 172 of 125.
This matter, my lord, our advocate, sir, is appearing for the read petitioner. His health condition is not good.
hmm?
His health condition is not good. Please for next circle. Taken next circle. Electricity.
An adjournment has been prayed for on behalf of the petitioner, though Mr. Misrol and the advocate appearing for the respondents is present. In view thereof. Tomorrow can we come? In view thereof. From unleash the matter for further consideration before the next available session.
Item number 19, WPA 195 of 125.
My lord, I am appearing for the petitioner.
Item 9. Yes, sir.
Yeah, before coming to the matter, I must submit that the respondents have not, service has been not affected for the respondent.
So why did you file them with 48 hours notice?
Therefore,
What you are challenging?
apparently in this matter, the
13th March 2023 complaint.
yes,
What's
complaint
that?
has been lodged by
Sure. Where is that complaint?
complaint in the next thing. P2, page number 2.
12.
Challan has been statement and a written statement has been annexed in page number 11. There is no written statement. Maybe FIR has been dropped out.
FIR has been lodged.
Yeah,
Then why you have come here?
launched, but here the matter is not that the FIR has been launched, the steps has been not taken properly. It is inappropriate for
Go to the criminal court. What will the lead court do? FIR has been lodged. If there is inaction on the part of the authorities, you have to hold them up in the charge sheet submitted, investigation complete.
no,
Oh, it's a 107.
there is no record in the court.
You're saying FIR has been lodged?
But no summon has been came with long time.
Where you have stated FIR lodged?
FIR has been annexed in page number 9, annex 1.
Then how can we help you? How can this court help you? What is your prayer? Your prayer is that you conduct investigation.
Where is Your Honor? They took me in the SDM. It is subdivisional magistrate. But it should be coming judicial magistrate.
The learned advocate appearing for the petitioner submits that service upon the respondent is not complete.
The petitioner.
এমনি সার্টিফিকেট কি থাকবে আমার লিস্টে আমাদের কাছে
Private respondent had to be served. आप हम लोग को दिया है क्या कॉपी कल? हम लोग को कॉपी दिया है? ओ, तो दिया है consideration.
My lord, the only allegation against private respondent is that they are covering the drainage, public drainage. So I made a complaint to the municipal authority to take action against that. So I made them a party in the writ petition. I sent by registered post, but track report is again, today also checked it. It is simply telling that item booked, 7-4, it is showing 7-4 item booked. But difficulty is there, my lord. I booked on my date is 4-4, I booked on 4th April. We are not updating the website. That is the problem. My facing. Second thing, Lord, now the
So if you take personal service, courier service, something you do, how can we say that? If there is urgency and if they are not intending to come, where do we find the record? You also know that there will be no circuit in the meantime. So urgency, part of April 2025, you should have taken steps. Now, what is your prayer?
The only prayer is like the municipality to take a direct action upon the person, the private respondent, to stop the ongoing construction of the completing the drainage and all. Let the construction of the work regarding the houses continue. I have no option for that. But they are covering the public drainage. I made a complaint.
Where is that?
Welcome to page number 16. Page number 16, I made the complaint to the building officer and 17, the municipal secretary. I made
Last all.
no.
You have stopped it, you are saying. Your state
But
is.
again they started. Again they started. But sometimes they stop it.
Yes, Mr. Chakravarti, do you have any instruction?
No, ma'am.
You didn't take any instruction.
We had sought instructions, my lords, but not been able to, my lord. Otherwise, my lord, it can be considered as that their representation can be disposed of after hearing them and the private respondent.
What I am submitting, my lord, direction can be given to the authority to dispose it of. There's no problem for them. But by the time they take action, they will complete the work. This is going on like this.
That we can.
But first thing, what they should.
This court cannot pass any.
They should, with the time frame, they should respect the site.
And come tomorrow. You effect service and come, we will pass the or consider your prayer certificate. But if you cannot effect service, how can we? You are seeking that this just to send should dispose of this no purpose.
It is not my way to restrain them from carrying out the work.
What is here?
Only drainage. Only drainage.
What that they are constructing, na?
Yes.
You want that construction, let it continue, but our drainage shall not be affected. So who can the rich court take such decision? It has to be by the municipality. I can send it to them.
Man.
But you are saying that won't serve any purpose. You want that the drainage should not be disturbed in the midst.
But they will complete the, my family, they will complete the work.
If they complete, it will be demolished if it is in violation. Choice is yours.
That's many.
affidavit of service, service affidavit you have filed?
Already.
আচ্ছা, আজকে করেছে, দেখি এটা। The affidavit of service as produced reveals that the writ petition was sent to the respondent numbers 3 by speed post. However, the track report towards such receipt has not been enclosed. But the track report as regards service has not been enclosed. However, in view of the order that is to be passed, fresh service upon the said respondent numbers 3 and 4 is dispensed with. Stop. Mr. Kumar. Mr. Kumar, learned advocate appearing for the petition. What is your grievance? I don't understand from your representative.
My grievance is working over drainage, so they should be stopped.
It is said Bidhan Chandra constructed or
Drainage.
there is a drainage, there is a drain
Yes, but-
between your land and Bidhan.
yes.
And Bidhan, Bala and other. Bidhan constructed over the drain and made this area.
Due to
So he's raising some construction which is affecting the drain. Huh?
That's my.
Learned advocate appearing for the petitioner alleges that the private respondent that submits that there is an existing drain in between the house of the petitioner and in between the house of the petitioner and others and the house of the private respondents. Stop. Such drain, stop, the private respondents who are raising construction over a part of the said drain, and as a consequence thereof, the drain has been partially blocked. The lack of partially blocked and the drain water, and as a consequence thereof, the drain water drain water stands spilled over the other areas causing nuisance. Accordingly, the petitioner submitted a representation to the respondent number whom you have submitted.
3 separate team.
Who will take this?
For the municipal council separate.
Building. Page 16 is building officer. You said.
Next page is secretary. The next page.
What the secretary will not take it. He will.
Building officer can be page 16.
Building officer has not been made a party. There is only building officer in your municipal.
Building officer is there, but building inspector, building officer. Both are. Not
Say something.
The secretary would recommend. Secretary for the municipal council.
No, right.
Secretary is a much higher officer, I think. of the council. He's of the Portobello Municipal Council. You must be having some building officer.
Legally, you want to add the building marks.
वो फर्स्ट पैराग्राफ के बाद एक पैरा लिखना कि as prayed for, comma, leave is granted to the learned advocate of the petitioner to leave is granted to implead. Is there any building officer?
Yes, yes, building officer, building inspector.
To implead the building officer, comma, municipal council. The learned advocate on record of the petitioner shall effect necessary correction in the cost title. Unless you do it, order will not be
I
signed.
will.
He will appear as respondent number 5. Creating news. A complaint to that effect was lodged to the added respondent number 5 on 30th January 2025, but no steps were taken. Aggrieved thereby, the petitioner has approached this court. क्या लिखा है ना उसके पास represent, but no steps were taken by the municipal authorities and no inspection was also conducted. Aggrieved thereby, the petitioner has approached this. Mr. Chakravarti, learned senior advocate, assisted by Mr. Kumar, learned advocate, comma, appears on behalf of the municipality and submits that the matter needs to be decided upon exchange of affidavits. Upon hearing the learned advocates appearing for the parties and considering the materials on record, now Mr. Chakravarti appears on behalf of the municipality and submits that the writ petition involves disputed questions of fact. Stop. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, I am of the opinion that no useful purpose will be served by keeping the writ petition pending, and the issue needs to be relegated to the competent authority. Accordingly, this court directs the respondent number 5 to consider the petitioner's representation dated 30th January 2025, added respondent number 5. Upon granting an opportunity of hearing,
Item number 31. WPA 210 of 2025.
My lord, this is that medical reimbursement, my lord.
Did you avail
Yes,
it?
my lord, I've obtained instructions. Now, my lord, under the Ayushman Bharat scheme, my lord, it is a cashless facility. So, my lord, when say if treatment was being done here, then of course it's a separate issue. But when treatment is being done in the mainland, they have to present the card and that hospital was to give free treatment. Now, if that hospital hasn't given free treatment, technically it is not, I mean, it is not the fault of the hospital here which has referred. However, I have received instructions that if they give a proper form with fault because they didn't give the invoices, etc., they didn't give the requisite documents, details. So let them give all of that, then we will recommend their case to that particular hospital for refund of that amount. So that can be done. It
Very
seems because
good.
there is an issue of, it appears that there is, we can't speculate, but it seems that, my lord, this is a case of long-term alcohol induced illness. So point is, but that is for that hospital to decide. It's not our. We'll recommend their case.
My client was a patient and patient was referred.
But we will recommend their case. Let them give all the apply with the documents. They are-
And who will be the authority? He will apply.
No, actually
Order 3, Director DHS.
yeah, yes, my lords. Director, respondent number 3 will then write to respondent number 4. Technically, it could have been resolved by issuing notice to respondent number 4 also, but as your lordship, my lord, we can write, otherwise notice can be issued to respondent number 4. They can come and.
He will not get the money. I will say that we will dispose of the director will take a decision.
Yes, yes.
Take a decision and intimate him the decision.
Yes, yes.
And when the petitioner's claim deserves acceptance, necessary follow-up steps shall be.
Yes, yes, my lord. That decision respondent number 4 will take actually. We will consider.
Why 4?
No, the
He is the giving person.
we will, no, giving person is 4. Giving person is 4 because treatment was undertaken in 4.
Treatment hospital is not.
That is my instruction.
The responsible for
My instructions are
hospital. The administration has issued the card.
What card?
Ayushman Bharat card.
Right.
Free treatment. He will give the money.
No.
Your purpose is to get the money. Who will give the concern? So if under this, it cannot be done without, we can call for this scheme, we can invite evidence, but that will not help you. That will kill make time. So we will dispose it off, we will ask the director to consider the petitioner's prayer on the basis of your fresh application along with all receipts of payment. We will give you time to file that within a particular time and they will take a decision and communicate to you. Decision will be, maybe they will be using a recommendation.
Yes, ma'am.
The present petition has been referred.
Yeah.
Why you're on the right hand? You're the petitioner, no?
Yes, yes.
No, usually petitioners are on the right hand side, no? But in our principal bench, we found it was like that. তাই না? না, তোমাদের এখানে ওই ইয়ে লেখা নাকি? For petitioners and counsels for the petitioners. লাগিয়ে দেবে রেজিস্ট্রিকে বলে দুটো ইয়ে করবে। Yes, madam.
Lordship, the petitioner has applied for the conferring the occupancy right from the non-occupancy right. Here, my lord, the allotment was done.
There are four kinds, na? Occupancy,
Non-occupancy.
non-occupancy.
Guarantees and license.
So he was conferred with the, he was given allotted with the land in the non-occupancy tenant. He was the non-occupancy tenant. He has applied for conferring his right as a occupancy tenant. Occupancy right.
So what relief, what benefit will that give you? Non-occupancy to occupancy?
Thereafter, he can sell the property.
Oh, I see, I see.
So
Yes.
he has made a representation on 28/12/2023, Madam. That is pending at annexure C2 at page 18, Madam. This is pending, Madam.
Now, where is that provision for classes of tenants?
Page 25.
141.
Page 25.
141 says the classes of tenancy. 141, Madam.
Page 25, regulation 141. Page 25.
140?
One. And with regard to conferring the right, 142A, Madam.
That is just 141.
140.
No, no, this is not. This is
First part, classes of tenants. Regulation.
yes. And what you are saying? What is the provision?
That is, my lord, 142A, my lord.
142A.
My lord. Every person who immediately before the.
What is in the rules?
No, my lord, in the same.
142, I do not, 142, that's every person, yes. Immediately from the council has acted.
Every person belonging to any of the.
What happened? This representation is not being considered.
I'm fulfilling the conditions, my lord, but there
Is the authority to consider. The present writ petition has been preferred, challenging the inaction on the part of the respondents to confer occupancy right to the petitioner in respect of the concerned land. Ms. Jeannie Learned advocate appearing for the petitioner submits that the petitioner is the petitioners.
petitioner is the joint recorded petitioner, my lord. Single
Petitioner is the joint recorded tenant under non-act. No, joint recorded tenant. Joint recorded non-occupancy tenant pertaining to the land detailed in paragraph 3 of the writ petition. His name accordingly stands recorded in the Record of Rights Incorporated annexed to the present writ petition. She further submits that on 28th December 2023, the petitioner submitted an application to the respondent number 2 for treating him as a occupancy tenant, right? occupancy tenant,
Yes.
occupancy tenant in respect of the said land. And to make necessary correction in the record of rights. Yes, that is what they will do. Ms. Das learned advocate appearing for the respondent submits that Ms. Das learned advocate enters appearance on behalf of the state respondents. Upon hearing the learned advocates and considering appearing for the respective parties and considering the materials on record, I am of the opinion that no useful purpose will be served by keeping the writ petition pending, and the issue needs to be relegated to the competent authority. Accordingly, this court directs the respondent number 2 to consider the representation submitted by the petitioner on 20th December 28th December 2023. Is that representation still there in their office?
It is there.
Huh?
I filed it in the diary itself, the diary is there.
Representation dated upon granting an opportunity of hearing to the petitioner and to take a decision in accordance with law. And to communicate the said decision to the petitioner. The above exercise shall be completed within a period of upon hearing the opportunity of it to the petitioner and other interested parties.
Others are there.
And other interested parties. And all other interested parties. Within a period of 6 weeks from the 8 weeks from the date of communication of this order.
Since affidavit has not been called for, the allegations are deemed to have to be accepted.
As affidavits have not been called for, the allegations made in the writ petition shall be deemed to have been denied by the respondents. Disposed of.
Obliged.
Item number 23, WPA 870 at page 91 as exhibit 3, certain reports has been relied by the deputy commissioner. And it was requested to Mr. Shivabalan to place the record, more particularly that report.
Have you got it, Mr. Shiva?
Not, I have bring the record, but from the inside that record, that report is not there. It is.
My lord,
In
the
the
thing is
original-
that no such annexure was ever prepared, no such report was ever prepared, even no such in the proceeding, no such report was produced. Hearing was
No.
concluded, the petitioner failed to prove anything. Thereafter, order was reserved, and subsequently I got the order that this thing has been happened and never produced before in the proceeding. I challenged the order before this honorable court, and the Honorable Justice Somen Sen set aside the entire order, that page 91. Entire order of the Deputy Commissioner was set aside. And my learned brother, when filed the writ petition, that order of Honorable Justice Somen Sen was suppressed. Subsequently, this honorable court directed them to produce, enclose those documents, and that judgment was produced by supplementary affidavit. That report is not in existence, that was set aside.
Then why the deputy commissioner will record that?
Yes.
If he record,
It was prepared. Yes,
you are at which page?
page 91,
Yes.
coming to page 91,
Hmm.
page 91, this thing, that in pursuance of the above schemes.
That's very good. I will ask the Tehsildar to produce the 10 extracts.
Yes, That
Your
document.
contention is no such document is there, no exhibit 3 is there.
They were produced in the proceeding.
Then why the person will refer to it,
I
sir?
don't know. And that is the reason this order was straightway set aside by this honorable court.
That may be there. That we are not concerned with that. We are wanting to know what is the truth.
Yes.
When a particular document says, I was about to throw out the writ petition,
And that's,
but when the particular officer's report says,
that is subordinate officer, but the higher authority says no such document is there.
where is that?
Yes. The,
Subordinate officer means the deputy commissioner.
no, this document is
Yes.
produced by Tahsildar.
No. Page,
Deputy Commissioner order.
let us come to the order, page 90.
Yes. In Tahsildar Award scheme, survey was carried out and on the provisional record survey number such and such.
Who is saying this, tell us?
Captured exhibit 3. From the exhibit 3, it is clear the future.
So this is the statement of the deputy commissioner. He, upon seeing the record,
This statement was at the basis of the report submitted by the Tahsildar. Exhibit 3 is that.
already have got the license,
Yes.
which contains a term for cancellation.
Certainly.
We,
Even earlier I got the license.
then we will dispose of the writ petition,
Yes.
recording this fact and we granting liberty to him to highlight this issue and pray for cancellation of your license.
Cannot be. Because of the reason, everything was decided. Even the Lieutenant Governor, the petitioner appeared there.
Already, Mr. Jaipal, you place your case.
One paragraph of the Assistant Commissioner Settlement, I will show page number 95 of the writ petition. Page number 95, third paragraph.
He has to accept the order, he has to accept the entire order, not in isolation.
And whereas in compliance of the order passed by the Honorable.
Let us. Yes, Mr. Shivalam, you have not found that annexure.
My lord, it is not there, my lord. In the file, it is not there.
In the record, it is not there.
Not that which the record there.
File contain the same number, but inside the file, the papers have been replaced. Not can you have a look with. At the top, the same file number carries, but the entire papers relates to the present date. It has been removed. So the order of the Deputy Commissioner 91, it's not there. It was find place in the same file, it's not there. Hard to say the report. Even the order of the Deputy Commissioner at page 91, it's not there in the file.
Have you filed opposition to this petition?
Yes. We have filed.
And what have you said about that report?
That is not in the pleading, my lord.
Out of the fiction. Connection people.
Anywhere it is said that that annexure is not in the file.
No.
So a government document which carries a particular statement which has been seen by the deputy commissioner, how can it go out of the file then?
But not seen by any of the parties. Where from this document came after conclusion of the hearing.
No, not after conclusion. It is on the date of hearing.
Before the Deputy Commissioner, when proceeding was going on.
Let us understand. Yes, Mr. Jawad, place your case. Let us see.
I am claiming the benefit of a scheme. Now, may I draw loss to the very scheme at page 76 of writ petition. Page 76. Now, under this.
Page 76.
76.
Yeah, the case has a checkered history, not three.
Absolutely not. But I would start with the order of this court. I can show that.
As a page 76.
76. Now, so the very object of this scheme to bring in is to regularize excess land beyond the recorded land in favor of those encroachers who are falling under pre-1942 categories. The condition would be survey has to be conducted a report has to be submitted, one who maintains the possession must be conferred with the benefit, and no premium is levied, no revenue is required to be paid. I am claiming benefit of this scheme. But when it was not done, I have been making representation to the authorities at one point of time, Lord. A license, one which has been issued now, which has been challenged here, has been issued in the name of private respondent. So that order, that was satisfied by the court. But kindly come to that order.
Mr. Haldar is appearing for whom?
3, 4 and 5.
3, 4 and 5. So you are the, now can you, Mr. Joypal, kindly come to page 52.
52.
The 550 square feet was recorded in the name of Kishore Lal and one was Kishore Lal and the other was Renuka Devi and Rajbir.
Absolutely.
And the other 550 square foot. No, that is the only one.
Yes, no. So far as Kishori Lal is concerned, it has been passed on to Usha Haridas.
No, সেটাই
Usha Haridas.
no. So Kishori Lal passed it on to
Usha Haridas.
Yeah, Haridas.
Haridas, yes, Haridas.
Usha.
Yes.
Yes. He transferred it to Usha.
Usha.
And Renuka and Rajvi
My client, Shobhasan, the petitioner here.
Then who is Radhika?
Radhika happens to be the successor.
My predecessor.
Means you are Usha?
No, no.
No, you
Radhika is my predecessor.
No. How Radhika, how does her name come into the picture? Kishori Lal, Renuka and Rajbir were there.
Yes.
Now
Their land was purchased by them.
whose land?
The
Renuka's land.
Renuka's land purchased by the petitioner.
Purchased by
purchased in the year 1989.
who Usha purchased?
Yes.
Usha has got
purchased Kishori Lal land.
to pertaining to Kishori Lal, Usha came.
Yes.
From
Look,
Kishori Lal,
this land is the
Yes.
adjacent lot of that excess land. This is the adjacent land.
let us understand.
Yes.
Kishori Lal was half of 550 and Renuka and Rajbir were half of 550.
Right.
Now after Kishori, who came?
After Kishori, Usha Haridas.
Acha, Usha Haridas came. Then Usha Haridas sold her share to Shobha.
No. The Renuka, the half share, Renuka and Rajbir sold their share to Shobha Singh.
Renuka and Rajbir sold it to Shobha Singh.
Yes.
Very good. And upon you, it has devolved through whom?
My father, Kanhaiya Lal.
Very confusing. Who is Kanhaiya Lal then?
Kanhaiya Lal is the father of Radhika Devi. The excess land was under the.
What excess? We want to know the devolution first.
Yes.
You show me the devolution chart. Who share, who got?
My lord, that 550 square feet, I don't have any control over that. That is a different landed property adjacent to my land. I don't have any control over it.
You have been granted license in respect of which one?
Adjacent land, not that particular one. That particular.
Achha, Mr. You tell me what.
The fight is pertaining not to a recorded land. The fight is pertaining to an excess land. The schemes comes into play
under the excess land.
That's one part one. Not so far as my client is concerned, Shobha Singh, page 52, she got the property from Renuka Devi, who happens to be the successor in interest.
Renuka came through Kishori.
Yes, they are successor in interest.
So Usha came into the picture from Renuka.
Lord. So, Lord.
So this 550 square foot is a part of the you have got Radhika got survey number 195. Shobha got 195 1B.
Yes.
And Usha got 195 1A.
A.
So Mr. Haldar came under which portion?
Not
Different land,
no, it's a
not this land.
Just 1 second.
Yes.
Take my pain, then I will not
Okay.
express my pain. Not this, and along with this property, my client held and possessed excess land.
Alright.
Contiguous to this land.
Mm.
That is in my possession. Mr. Anando Pride says that excess land is in his possession. I say it is in my possession. Just to ascertain the ground reality, survey was held. In this survey, it has come that we three of us are there. Haridas is there, Anando's client is there, and my client is also there. In terms of the scheme, the license, I'm just
It has to devolve upon the possessor.
3 persons.
3 persons.
On page 91, Deputy Commissioner for any reason turned down the order was set aside. The order-
Acha, now tell us the sequence, then you made the payer under the regularization scheme when? That scheme 56 which you showed.
This one, drawing lots of them. It was after the scheme being brought into force, not after 2003.
Then that was not considered.
High
You,
Court District Court.
very good. Then
The writ court passed an order.
page
I'll just show you.
that you have not annexed. You have annexed this order of the Tehsildar.
That I have not annexed lordship. Based on that direction, page 74 came to be passed. Page 74.
No, first tell us how 62 came. 62 is a representation of Shobha Singh. That is your client.
Malo.
Here you have written.
Malo.
So this your first representation that is of 17th November 2007.
Malo.
Report reveals that a double-storied building is constructed by Radhika over 195 over there. Complainant Shobha is recorded tenant of 195 1B.
Malo.
Another part of this survey stands in name of Usha.
Yeah.
Mr. Haldar is through Usha and you are Shobha.
Malo. Next one. All the above mentioned 3 parcels of land has a provisional survey number of 1059. These lines very important.
Well,
Not
subject to correction, I am not through. I am through my father Kanaya Lal.
Let us see if the jigsaw puzzle is resolved.
Page 62, immediately thereafter, which one have read, all the above mentioned 3 parcels of land
Yes.
has been given a provisional survey number 1059. Meaning thereby, over 1059, I maintain my possession, Mr. Anando's clients also maintain possession, and Haridasi also maintain possession.
Where is Haridasi coming?
But all the above mentioned 3 parcels, page 62,
All the above
3
3
parcels of, one is held by Haridasi, one is by Radhika Devi, one by Shobha Singh. And it not,
Radhika, Shobha and Usha.
yes. So these 3 plot of land was given a provisional number as 1059. In the same land, there was an excess land. When we 3 maintained the recorded land, obviously the excess land was also held and possessed by us. So only page 91 came into force. The surveyor report says that we 3 of us are there over the excess land.
Now he has been granted license in respect of which portion?
1059 excess land. I'll show the license.
Now what happened after this? After this was issued on 19th November 2007. Then what happened?
Nothing was done, my lord. I have been approaching the authority.
Hmm.
Page 74, not annexure P8 came to be passed by the authority, by the concerned Tahsildar.
Yeah,
Page
just
74.
page 74.
74.
Hmm.
I'll just read this page 74 now.
No, why you are going to 74, Mr. Joypal? There is an order at page 66.
This is an order of the division bench.
No, please show us the sequence now. What happened after this observation on 19th November? What happened? Page 64 is an order. What order is this?
This is an order with regard to surrendering of a part of land, which has nothing to do because it's part of annexure. This has nothing to do.
Okay, tell us which page you are showing.
Page 74. Page 74.
Hmm. Page 74, yes.
I'm just placing the handwritten order. Case called out. Srimati Radhika Devi and her counsel Arbitration brothers. Srimati Usha Devi, Usha Haridas and her son Harish Kumar.
Kumar. Clear what? Acha, ঠিক আছে. Radhika and her counsel appears.
Yes.
Usha Haridas and her son appears.
You see the revenue records, it is clear that Kanayalal and Sri Brijlal had the possession over old survey number 1059, measuring area 683 square meter. After their death, Srimati Radhika Devi has possession over excess land of 302 square meter. There is no evidence that the excess area is in occupation of Srimati Usha Haridasi and Srimati Shobha Singh. Srimati Shobha Singh absent today. I direct, make record accordingly and issue license. This order, not page 75, may kindly be seen.
Which went in Mr. Havlar's favor.
My lord, this was challenged. At page, I'll show that order, page 78. This order assailed in this court at page 78. I'm just placing this order. By this petition, the petitioner claims to be the recorded tenant as per the provisions of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation 1966 in respect of land clearing survey number 195/1/D, area 550 square feet situated at Jangiat village, Port Blair, Tehsil. She has challenged the order dated 30th September 2013, pursuant to which license dated 12th November 2013 was issued by the administration to the private respondent to occupy land for house site upon adjudication made on 30th September 2014. She complains she did not have notice of the said hearing. Pursuant to the order dated 1st September 2014, the records have been produced by Mr. S.K. Mandal, that is senior advocate appearing on behalf of the administration. It appears from the record produced, the petitioner was present by the London advocate on 25th September 23, which was a date, hearing date please. The private respondent was also present on that day. The London advocate for the petitioner had put in an application praying for adjournment and had left the court. It appears in his absence, the matter was taken up by the adjudicating authority and the prayer made on behalf of the petitioner by application put in as aforesaid was allowed, and the next date of hearing originally fixed on 4th October 2013 and later amended to read as 30th September 2013. Obviously, in absence of the London advocate appearing on behalf of the petitioner, the order sheet reflects that the direction for issuance of notice. Peruse the rest of the documents contained in the file, including the notice dated 26th September 2013 issued pursuant to the directions recorded in the order dated 25th September 2013. The said notice was addressed to 3 persons being the.
No, come to the last paragraph.
In last paragraph, page 79.
Prima facie case made out.
My lord.
Set this 30th November was set aside.
My lord. That was set aside along with the license. Consequent steps of issuance of license was also set aside at page 79.
Page 7.
Last paragraph may kindly distinguish order and the consequent step of issuance license was set aside.
Very good. Now, where is this 30th November order? 30th November 2013 order was set aside.
My lord. That's not. It's 74. Page 74.
74 is the handwritten.
Not to find down below signatures, dates. Mr. Arul Prashant's signature with date 30th September.
That was set aside.
Set aside. So the order and grant of license both were set aside. The matter was remanded back to the authority.
So the license was issued in whose name now?
the criticism of the present private respondents.
Very good.
Then, Lord, the deputy commissioner at page 81, in terms of the directive so passed at page 78, passes an order again at page 81. This order was passed by the Assistant Commissioner Settlement. I'll show that. 81. Lord, see,
Hey, come to the relevant page.
Lord, 83.
Hmm.
The Assistant Commissioner has said that he cannot take a decision, and liberty was granted. At page 83, I'm reading at the third paragraph.
Oh, it was sent to Deputy Commissioner.
Not Deputy Commissioner. Then this order dated 13 was
12/12/2015.
This is 12th December 2014.
Yes.
Next, the order was passed in page 90, I think page 91.
Hello.
Page 90.
190. So there, page
Is,
91.
is this the order after that letter? There was, what is page 84 then?
84, I'm coming to that. Just one second.
12 December Assistant Commissioner, I have no jurisdiction.
Hello. So this order was challenged
That was
at page 84. Page 84.
Oh, that Mr. Haldar challenge.
Hello.
Then what happened in that?
Also, Honorable Court directed me to file a representation before the Deputy Commissioner and Deputy.
Because he has no
Yes,
jurisdiction.
and the direction has been given to the Deputy to ascertain the fact.
And pass it final.
On the basis of the revenue record, appropriate order be passed.
Very good.
Page 90 came to be passed. Page 90.
Achha, page 90.
I'm on the page 91.
No.
Lordship, page 91, it starts with fourth paragraph from the bottom, in pursuance. So survey was conducted in pursuance of the above schemes. Survey was carried out, and on the provisional record, survey number 105 in the possession status was captured exhibit 3. From
Where you are reading?
from page 91, fourth paragraph from the bottom. Fifth, it's
Fifth paragraph.
Fifth paragraph.
Achha, in pursuant to the said scheme, survey was carried out, and on the provisional record of survey 105, possession status was captured.
Captured, exhibit 3. From exhibit 3, it's a report, Lordship. Survey was done, it's not merely a survey in air. There's a report prepared as marked as exhibit 3, which was placed before the Deputy Commissioner. From the exhibit 3, it is clear that Srimati Radhika Devi, Srimati Shobha Singh, and Usha Haridasi were shown in combined possession of 302 square meter of in this same survey number 1059, which is an excess land. So my point of argument is, Lordship, while granting license now, which I have challenged here, why this report was ignored? It's a relevant consideration, Lordship. They do not want to take a decision, they should have rejected it.
So very good. After this order was passed, this was passed on 1st July 2016.
My lord.
Now, against this, anybody, what was ultimately directed? Why this was
Directed, my lord, I'll show you.
license issued on such and such for enter 302 in the one co-tenant decision is not correct regarding Shobha and Usha, that the land is illegal or what, they are advised to approach appropriate forum.
My lord.
So this order went against Usha.
Radhika and my client.
And in compliance of this order, they already filed a civil suit for the.
Sort of these points are messing up the entire issue. Just need to understand. Messing up the issue.
So please, you have come from they're very confusing. This, so Radhika, Shobha, and Usha were found to be in possession of the excess.
Excess.
And in terms of the scheme, it is
Yes.
to be regularized.
Yes, that is my point of argument.
Very good, we understand. But now, when what decision is taken, there is a excess land regulations are meant for all co-tenants who have maintained continuous. In the instant, is one of the co-tenant has sold out the allotted plot.
Well,
Who is that?
my client still not retained the property.
Achha, therefore, the entire 302 was under possession of both co-tenants in 1961.
Cannot be
Okay, building it in-
only one co-tenant.
Hmm.
Therefore, the license issued on 12th November 2013 for entire 302 in the name of one co-tenant descendant is not correct.
So this one co-tenant is
Yes.
you are Radhika.
Yes, my lord. The deputy commissioner holds that it can't be done in the sole name. regarding the claim of Shobha Devi and Haridasi that their land is illegally or they are advised to approach the appropriate forum authority. This liberty which has been granted to me was.
So you are hailing from whose portion? Usha Haridas?
I am my own independent person.
Shobha.
Yes.
You are Shobha. And Mr. Haldar is coming from Radhika.
Radhika.
So who is this Usha?
She is also maintaining the possession. She is also there, no? She is
So,
no way connected with us.
so Mr. Haldar is pertaining to the share of Radhika,
Radhika.
who was a co-tenant along with Shobha and Usha. Right? Shobha and Usha. Very good. Now, this order was challenged by Mr. Haldar. Then what happened?
It was set aside.
Oh, this order went.
But the report relied by the deputy commissioner was not able to never brushed aside. Simply the matter was relegated back to the authority to take a decision afresh. You know decision.
That report said I am in absolute opposition.
Achha.
So, when the matter was sent back, again a new report comes in, where I have been excluded. Saying that I am not in possession over the 302-10597.
Where is that report?
No. It's at page 93, the order of the deputy commissioner and the finding at page 95. Last but one paragraph. Page 95, last but one paragraph.
And where is in compliance of it?
94, last but, and whereas in compliance of the order passed by the Honorable High Court of Calcutta, called for.
No, this order is being passed after the page 91 order was set aside.
Yes, no.
Set aside and it was sent back to the authority
Yes.
considered afresh.
Yes.
Where is that order? That is also not added.
Supplementary, it was not initially enclosed. Thereafter, Honorable Court directed them to.
I was not made a party willfully. In that proceeding, I was not a party. Order was
Proceeding your party, you participated in the
The
proceeding.
order passed by this court where they got the order under the party.
The proceeding you have participated in the entire proceeding.
Supplementary affidavit. There must be a
I have
supplementary.
included with my affidavit in opposition.
Oh, then it will, Stephen, it is in, you are 3, 4 and 5 9. Hearing it has been enclosed.
I
Now,
think even the opposition itself.
now what happened? In the new order which is passed,
My lord.
that is page 93,
My lord.
it proceeded on the basis of, it referred to, whereas consequent, page 95,
My lord.
whereas consequent upon above mentioned order, the district by 1st of July 2016 disposed of the representation. That is page 92.
My lord, please-
Now, to kindly place and whereas in compliance of High
Page
Court.
95.
Hmm.
And whereas in compliance of the order passed by the Honorable High Court
Hmm.
of Calcutta, called for all the records and scrutinized the affidavit in opposition filed by Sri Santosh.
Is this Santosh?
He was the
Assistant
Assistant
Commissioner
Commissioner Settlement who affirmed an affidavit in the previous petition. Certain reports were relied.
AC settlement is the recommending authority.
Yes. So where is this Santosh's affidavit? How we will find? It is there.
So far I remember, I have enclosed that affidavit along with my affidavit in opposition. Just a minute.
So the whole, as I narrated the stand taken on any category stated in paragraphs Q and R that Shobha under the pretext of clearance of her approach has the ulterior motive claiming excess area. No occupation or so this report was relied upon.
My lord.
Moreover, pre-61 survey report and settlement as well as report. Where is this 9 clearly shows?
Yes.
19th November 2007. Where is this 19th November 2007? Very confusing, very confusing. So many rounds of litigation.
But the order dated 6 December.
Yeah, just Mr. Haldar, let me understand. Where is this? Read moreover the pre-61 survey report of the survey settlement as well as report of Tehsildar Port Blair dated 19 November 2007 clearly shows that neither Shobha nor Usha have any portion.
I've been excluded.
Excluded. Where is this 19 November 2007? Is that page 62?
That's one.
That is page 62.
My lord.
This is the representation submitted by the representation.
Take 62, my lord.
This
62 says it's in the name of, it's occupied by 3 persons, having the provisional survey number of 1059.
You are saying, not the authority. You are saying.
Authority said in page
No,
9.
no, this is your representation. This is an application submitted.
Mr. Haldar, somebody has to stop. You are dealing with the litigation for 15 years. I have not spent at least 2 days also in this. It's very difficult factual aspect. You please relax. We will give you, if I pass any order against you, I will hear you. So you don't have to worry. So now, on the basis of this order, what did the ultimate say? Next para, administration after carrying out the survey found Radhika is in occupation over excess ato, originally under occupation Kanhaila and recommended for regularization. This finding is contrary to page 91. In view of the such and such, being the descendant Radhika are entitled to get, your argument was this observation is tentative.
Lord, may I say one thing? If the authority choose to carry out survey more than once, in one report, it's in my favor saying that I'm in possession. In the other report, which crystallized in passing the issuance of license, it's against me. But my report, which I have relied, ought to have been taken care of because it was prepared based on ground reality. Survey conducted is on the ground, saying that the
But that is missing.
But they authority not, it's deliberately withheld before this court. When reliance has been placed, and particularly when the matter has a checkerboard history, and particularly when, Mullah, to see the first order of this court, when this court turned on my interim prayer, authorities were specifically guided by her ladyship Justice Sabita Sinha. In your opposition, specify who is in possession.
Where is that order?
While entertaining the repetition, when my interim protection was turned out, I'll show that order. By her ladyship, Marshal.
Now, what is the present status now, Mr.?
Man, I'm in possession. How could the license be given to the private explorer? That is my point. Scheme comes to my aid. Give it to them, but I'm also a licensee. The licensing must be in the name of 2 persons. That's it. Harita Singh is not coming forward, then Shobha Singh is entitled because she has maintained the excess land along with the recorded land. Not kindly in the first order, 17th August 2023, order passed by this court in the present date. My interim protection was turned on. Page 2 may kind last but one paragraph may kindly be seen. The official respondents in their opposition shall annex the report reports not kindly see. Even this court was desired that by the filing opposition this must comes in. The official respondent in their opposition shall annex the report relying upon which the authorities concluded that the private respondent are in physical possession of the land in question. So they must submit all the reports.
So in their opposition, they have.
It's not there. And now when the records were requested to be called for, file number is same, but the interior papers have been replaced. The documents are deliberately withheld, not so that if it comes in, it may the court may consider it in the way with the repetition may asking. So how that
Mr. Sivalam, you file an affidavit stating that the document is missing. You put it on record.
My lord.
You have given inspection of the file to Mr. Jaipal as well as Mr. Haldar.
Yes, my lord.
And there was a dejection. The doubt is that whether there is no doubt that Mr. Haldar has a portion of the land. There is a regularization if done. Then in fact 3 licenses have to be issued. One in favor of Mr. Haldar, another in favor of Mr. Jaipal, and the other was in favor of the other person. Usha.
My lord, I have not argued. Whatever submitted, that is absolutely wrong.
Exactly, your contention will be, it is bigger submission which is being made.
This is the.
But the court wants to get a written information that we do not have that exhibit.
I am telling my lord, that annexure 3, that is the survey report. The survey report specifically proves that I am in absolute occupation of that excess land.
Then why it will be said that there are 3 lands?
Wrong submit, wrong,
So wrong has to be corrected, Mr. Halder.
wrong has been corrected by this honorable court. In
Wrong.
Committee number 327,
Where you scored me one document where it has been said exhibit 3 is bad.
the entire order has been set aside.
Entire order has been set aside because it was not having, the person was not having jurisdiction. Set aside that and send it to the appropriate.
What is annexure 3, I do not know. But they are saying about.
Annexure 3, nobody knows.
My lord, let me complete. But they are saying about the recommendation given by the administration. But the recommendation I can produce, that in the recommendation, serial number 195, my name is appearing there, that I am in absolute occupation. They are nowhere. They came into existence and the adjacent land in the year 1989.
Where have you raised that statement, Mr. Halder?
I can show that document.
In case of hearing, have you ever shown where is your affidavit? In your affidavit or the annex?
I will show.
No, I want to see this exhibit. This has to be brought on record. If they say that it is not on your record, Mr. Shivalan, you make the statement that that document is not in our file.
I will ascertain. So again, Malad, if it is not.
No, I am giving you liberty to file an supplementary to this.
Affidavit.
I will make my observation. You file that supplementary affidavit before me. File that and in the supplementary report, I will record Mr. Halder's contention also that this annexure 3 has never been produced. Then how did the water flow? Then ultimately, then what happened? Then this order was passed, you went up in appeal. Against this order, you filed fresh writ petition. Oh, no. Against this order, yes, page 97.
97, Lordship, was with regard to
an order of 22nd December. What is that?
yes.
Appellant had filed WPA 313 in which such and such.
Yes.
Get the price.
93 was challenged, page 97, Lord. Page 93 was challenged because brought to find second paragraph in the intra-court appeal order. This order at page 93 was challenged. Brought to find second paragraph of page 97.
It is submitted by Mr. Jaipal that the appellant.
That the appellant had filed WPA number 313 of 2018, in which Shabab Ali and 2 other respondents, that is son and daughters of Shabab Ali, were private respondents / OPs. The appellant had filed the apostate writ petition with a prayer to quash the order dated 6/12/2018. It's at page 93. Passed by the Deputy Commissioners of the Naman, in which the recommendation was made for issuance of license in favor of apostate Shabab Ali. The apostate Shabab Ali filed WPA number 92 of 21
for implementation.
by implementation. And Lord, would see by the division bench held in Lordship because when my writ petition and their writ petition WPA number 92 of 2021 was disposed of on a wrong submission being made that it was implemented. Whereas the fact remains when WPA number 92 of 21 was not disposed of, no implementation was carried. So they filed a contempt application. It is during the contempt application that the order was implemented. I'll show the cost.
So did appeal court granted you leave either you
petition or withdraw it, file a fresh, I file a fresh one, which is the present one.
And in the meantime, the license stands in the name of Mr. Bhai.
Yes, yes.
Pursuant to the earlier direction of this court, affidavits have been exchanged by the parties. in course of hearing, placing reliance upon an earlier order So in course of hearing, Mr. Joypal, learned advocate appealing for the writ petitioner, has drawn the attention of this court to an order dated 1st July 2016, passed by the respondent number 2. Passed by the respondent number 2. The relevant portion upon which reliance was placed, क्या बोला, in course of hearing, Mr. Jam, has wherein it has been observed as follows. As follows, please quote. I have page 91, in pursuance to 302 meters. Square meter, sorry, square meter. Mr. Jaipal contends that in terms of the provision, that as per the scheme of regularization dated 15 June 2003, the petitioner was entitled to get license pertaining to the property pertaining to the property in Exhibit 3 as produced before the respondent number 2. From the said, it is in view of the said Exhibit 3, according to Mr. Joypal, it cannot be said that the petitioner was not in possession, was not in combined possession of 302 square meters of land along with Radhika Devi and Srimati Usha Haridas. Such contention has been vehemently opposed by Mr. Haldar, learned advocate appearing for the private respondents. Let such supplementary affidavit be filed within 2 weeks from date with copies to Mr. Jaipal and Mr. Haldar. And he said, and they would also be at liberty to file supplementary evidence in reply. Within 2 weeks thereafter. Please the matter for further consideration before the